What is a securitization audit? A securitization audit is a detailed report on the chain of title of your mortgage note. It will show violations of New York trust law and violations of Internal Revenue Code regarding REMIC status. Now, sometimes these violations don't exist, but in most cases when we examine a loan that was securitized, we find violations not only of New York trust law and sometimes also of state and federal law, but we also find those violations regarding the Internal Revenue Code regarding REMICs. A REMIC is a real estate mortgage investment conduit and is essentially a tax-sheltered opportunity that functions very much like an S-corp that allows the owners of a REMIC to receive the proceeds or profits without double taxation. In other words, the profits flow through directly to the owners rather than being taxed at the corporate level as well as the distribution level. So it's a major benefit for these particular mortgage trusts to have REMIC status. A securitization audit also provides strong evidence that the party that purports to own your note does not in fact own it. Again, in many cases when we do a securitization audit, we find that the trust claiming to own the audit never gained legitimate possession of the note through chain of assignment and therefore does not in fact own it. And this can then be used as a powerful tool in litigation against a lender. Now, it's also important to know what a securitization audit is not. A securitization audit in and of itself is not likely to get you a modification in the absence of litigation or at least a threat of imminent litigation. It's highly unlikely, contrary to what you may have heard or been told, that a securitization audit is going to result in you getting a free house. There have been cases where judges have essentially ruled that somebody is going to get their home mortgage free. But keep in mind, that's after extensive litigation, and those are very unusual circumstances. A securitization audit is also not a forensic audit. Forensic audits look for violations of RESPA, which is the Real Estate Settlement and Procedures Act, the Truth in Lending Act, etc. And a securitization is also not a title search. A title search tells you about liens placed on the property and not the history of the ownership of the liens and underlying instruments. The next thing that we want to discuss is what is securitization? Securitization is when a significant number of mortgage notes are pooled together into a trust, and then that trust is sold to investors who purchase that trust or shares in that trust in order to gain a return. And the process, which is highlighted here in this particular presentation, is that first an originator sells a loan to a consumer and a note and a mortgage are created. The next thing that happens is a financial institution buys up a significant number of these notes, which again are guaranteed by mortgages, and pools those loans into a large group. They then hire and work with a depositor who is responsible for taking that pool and creating the trust or the instrument that can then be sold to the end investors. Once that trust is created, a trustee is appointed that manages the pool and is supposed to represent the interests of the investors who buy certificates in the trust. Those trust certificates are then marketed by an investment bank that is hired by the financial institution that pooled the loans, and that investment bank sells those trust certificates to investors. So essentially, the certificates in the trust pass through the investment bank to the investors. The investors pay for those certificates and the proceeds go back to the financial institution that pooled the loan. And so essentially that financial institution that pooled the loan is able to create a saleable instrument that is sold to third parties. And then, as I'm sure you're aware, those interests or those trust certificates are sold over and over. And so the ownership interest in that trust changes many, many times in a lot of cases. It's important to note that as a mortgage passes from one of these entities to the next, from the originator to the financial institution that pooled the loans, to the depositors, to the trust, each one of those represents an assignment of the note. And at each one of those occurrences, the note should have been endorsed over to the new owner appropriately, which means that an officer from the company making the assignment would have needed to sign the note, and that would be a notarized signature. In most cases, those things never took place. So in fact, the trust never got valid possession of that note. In some cases, it was done correctly. But in the audits that we do, we very rarely find that a trust has legitimate ownership of one of these notes. And that's a major piece of this puzzle. So exactly what did go wrong with securitization? Well, the transferability of an asset plays a major role in its value. The easier it is to pass ownership of an asset from one party to the next, or the liquidity of that asset, plays a major role in what somebody is willing to pay for it. The trusts that were created under New York trust law that owned these pools had very specific acceptance and transfer requirements for mortgage notes. And these requirements had a tendency, and certainly do, slow down the process of creating and selling trust certificates, because there's a lot of paperwork to be done in that process. Therefore, the major players in the mortgage industry created mortgage electronic registration systems. This is essentially a system where each loan got what's called a MIN, a mortgage identification number, and was transferred within the MERS system when sold. And what that meant was, instead of the appropriate wet ink signature endorsements happening each time ownership of a note transferred from one entity to the next, all that happened is the entity that it was registered to in mortgage electronic registration systems changed. So the upshot is that the mortgage transfer requirements mandated by New York State trust law and by local state law were intentionally ignored and broken by these lending institutions in an effort to churn these transactions as rapidly as possible and to create as much profit as possible. So what could this mean to you? If the note is not validly held by the party who is foreclosing on you, you may be able to permanently stop them from foreclosing. A securitization audit is able to help you determine that. If you're not in foreclosure, you still may be able to file a suit to quiet title and may have other remedies that would put you in a very powerful bargaining position with the bank if they in fact don't have the right to be collecting your payments. By becoming informed and building a powerful suite of evidence, you could gain the upper hand in negotiations with your lender, whether you're trying to achieve a modification or stop a foreclosure. Being informed and knowing what your situation is makes a huge difference. If you do decide to file a suit against your lender, Legal Forensic Auditors recommends you do so by utilizing the skills of an attorney who is familiar with litigating against mortgage lenders. And that is becoming much more common. In the 60 Minutes interview that was just done this past Sunday, first week in April, Sheila Bair, chairman of the FDIC, stated that there are about 30,000 of these cases going on right now. So obviously there are a significant number of people who are stepping up and using this type of a platform to litigate against their lender. The next thing is there are success stories. There are consumers who have taken on their lenders and have won the war. And I want to share a couple of those with you because they are significant and the tide is changing. In other words, courts are starting to see that there has been a systematic abuse of the foreclosure system by lenders, and they're now hearing cases where homeowners are standing up and saying, hey, wait a minute, this person doesn't even have standing in court. So let's take a look at a couple of those. The first case that we want to look at is the Ibanez case, which is a Massachusetts Supreme Court case that was just adjudicated this year. And this is a case that started in the lower court, went through to the appellate court, and went all the way then to the Supreme Court. And in the judge's decision on page 8, the following language is very damning for the mortgage industry and securitization industry. To foreclose on a mortgage securing property in the Commonwealth, one must be the holder of the mortgage. To be the holder of the mortgage, one must be the original mortgagee or be the assignee under a valid assignment of the mortgage. It is not sufficient to possess the mortgagor's promissory note. The land court correctly held that the plaintiffs, U.S. Bank and Wells Fargo, were not holders of the Ibanez and LaRace mortgages at the time of the foreclosure because they were not assignees of valid assignments of the mortgages. Without valid assignments, the plaintiffs lacked the legal authority to foreclose the mortgages. This, without more, is sufficient grounds on which to invalidate the foreclosures, and the land court was correct to do so. So this is actually a situation where you had homeowners who were foreclosed on who sought to vacate that judgment, to reverse those foreclosures, because they were able to show that the plaintiffs, the foreclosing parties, lacked sufficient standing as a plaintiff. In other words, they did not have valid possession of the note. And that has sent a wave through the country, and there is now a tremendous amount of litigation being filed that is citing the Ibanez case as precedent. Another case that is very telling about the status of this type of litigation just took place in Russell County, Alabama, and it was Horace versus LaSalle. And again, what we have here is somebody who challenged the bank's right to foreclose based on chain of assignments. And there are some incredible language within this case. And the plaintiff actually won a motion for summary judgment. And this is actual language from the judge's order. First, the court is surprised to the point of astonishment that the defendant trust, LaSalle Bank National Association, did not comply with the terms of its own pooling and servicing agreement, and further did not comply with New York law in attempting to obtain assignment of plaintiff Horace's note and mortgage. Consequently, plaintiff's motion for summary judgment is granted to the extent that defendant trust, LaSalle Bank National Association, is permanently enjoined from foreclosing on the property at 3745 Knowles Road in Phoenix City, Alabama. Essentially what the judge has said is, you don't have the right to foreclose, nor do we believe you ever could. Therefore, we have permanently enjoined you from foreclosing on this property. Now, keep in mind that there is somebody who is, based on the chain of assignments, a valid holder of that note. And I believe that's an entity called Encore. However, keep in mind that Encore sold that mortgage and essentially received funds against it when they did that. So the likelihood of them coming forward to foreclose is much lower. So this presents a really significant problem for banks like LaSalle who are unable to prove that they have valid ownership of the note. Now, from the plaintiff's motion, in other words, the actual statement from the plaintiff's attorney, the following statement was made, and again, the judge ordered favorably based on this motion. Based on the law, the terms of the pooling and servicing agreement, the failure to show the proper chain of endorsements and the arguments contained herein, plaintiff moves this court to permanently enjoin LaSalle Bank National Association from foreclosing on the property at 3745 Knowles Road, Phoenix City, because they have failed to make the required showing that they are, or ever were, or ever could be, the holder of the mortgage promissory note. So it's not just they don't have the right to foreclose now. Because of how New York trust law is worded, and because this document or this note was not validly transferred into the trust, and the trust is now closed, typically the trusts close about 90 days after their start date, they are not allowed to take in any additional notes. So if it was not put into the trust originally through a valid transfer and the trust is now closed, it can never go into that trust. Very, very powerful stuff. Now, you've probably also seen some of these things in the press and want to share with you a couple of recent press articles that I think tell the story about where things are headed. 60 Minutes just did a great piece on April 1st, and in that piece, the statement is made, it's bizarre, it turns out. Wall Street cut corners when it created those mortgage-backed investments that triggered the financial collapse. Now that banks want to evict people, they're unwinding these exotic investments to find that often the legal documents behind their mortgages aren't there. Caught in a jam of their own making, some companies appear to be resorting to forgery and phony paperwork to throw people down on their luck out of their homes. The Palm Beach Post, also on April 1st, did a review of cases in state and appellate courts and found judges are routinely dismissing cases for questionable paperwork. Although in most cases the bank is allowed to refile the case with appropriate documents, in a growing number of cases, judges are awarding homeowners their homes free and clear after finding fraud upon the court. And guys, this is happening over and over. However, Is it the norm that when you litigate against your lender and when you seek this type of an outcome that you actually get your home free and clear? Of course not. And that's really not what most people want. They just want fair treatment from their lender. The way to do that is to step up and demand fair treatment. Perhaps the only thing more important than what you see in the courtrooms or in the press comes from the horse's mouth. And from Bank of America and mortgage electronic registration systems, two of the major players in the mortgage meltdown, we've seen recent statements that are very telling of their own admission to the problems that exist. In Bank of America's 10-K filing for last year, they stated many derivative instruments are individually negotiated and non-standardized, which can make exiting, transferring, or settling some positions difficult. Many derivatives require that we deliver to the counterparty the underlying security, loan, or other obligation in order to receive payment. In a number of cases, we do not hold and may not be able to obtain the underlying security, loan, or other obligation. This could cause us to forfeit the payments due to us under these contracts or result in settlement delays with the attendant credit and operational risk as well as increased costs to us. We don't have the note, and we may not be able to collect payments. Very powerful statement. Mortgage electronic registration systems, in an announcement to their own membership, stated, MERS is providing the following guidance to all members to strengthen business practices and minimize reputation, legal, and compliance risk to MERS and its members. In recent months, legal challenges have arisen regarding alleged inadequacies and improprieties in the foreclosure process, including allegations of insufficient or incorrect supporting documentation and challenges to the legal capacity of parties' right to foreclose. They go on to say MERS is planning to shortly announce a proposed amendment to Membership Rule 8. The proposed amendment will require members not to foreclose in MERS's name. We encourage members to bring foreclosures only in the name of the holder of the note, in the name of the trustee, or the servicer of record acting on behalf of the trustee. Guys, these are internal admissions that these companies have not been following appropriate protocol, and they're recognizing the need that they have to change that behavior.